I beg to mention item number 18, Lordship. Yesterday. Okay. You have informed the other side? Yes, he has filed an application for it. Okay. Okay. With consent of the other side, Mr. ABT Hawk, counsel for the appellant, prays for adjournment. Prayer is allowed. List after 2 weeks. 2 weeks. Wait, please, just a lot. This matter is ready for hearing now. I'm praying for listing on my private file. Give it to the court master. They will have to make some adjustment. There is a long pendency of all matters. They'll have to make some adjustments. We are now taking up 2020 and post 2020 hearing. I beg to mention item number 11, not sure. What is this IA for? Out of station. Okay. List after 2 weeks as paid for by counsel for the applicant.
Division bench, item 1 for admission.
Yes, sir. But I'm appearing on behalf of NSB Global. She's out of the session.
Okay. Mr.
S. Rana.
S. Rana, counsel for the appellant. Bill under 374, order dated transfer, page 1. Please admitted for hearing. Call for the records. Issue notice on respond number 2, returnable on so and so. The appellant shall take steps within 2 days for service of notice on respond number 2 by registered post with AD. Moreover, additional process shall also be filed so as to enable the registry to process the same and hand it over to the to Ms. S.H. Baral and APB for onward service of notice on the respond number 2 through the jurisdictional police station and report of service and to report service list on so and so. Give a date after 5 weeks. You have to give additional process. So it will go through PP also. Item number 2. Okay, you're there, Mr. R. Chakravarti, counsel for. Also, Hardev, I'm sorry. Hardev, counsel for the appellant. Same order. Respond number 2. Here also this same.
Name may be deleted also.
Pardon me?
R. Chakravarti is not.
He's no longer there. Okay. It is submitted that Mr. R. Chakravarti, learned counsel, is no longer appearing in the matter. Hence, registry shall delete the name of Mr. R. Chakravarti as counsel for the applicant while listing the matter next. Now, there is an IA for bail. IA notice, period for bail shall be considered on receipt of LCR. And service of notice on respondent 2.
28 February.
Yes, item 3.
Perhaps.
Yes.
We have taken steps, Lordship. The office construction has promulgated 6/1/2024. But this is yet this sort of understanding.
And what about the police through service through police?
Take instruction to that.
Okay. You can get it today.
Lordship.
We'll take it up at 2 o'clock. Otherwise, there will be unnecessary date. Let's wait for some time. Mrs. Bora, we'll get information.
Lordship.
It's item 4.
Item 4,
The order of which Beckham says the legal counsel Mrs. S. Beckham was not present.
Pardon me?
Lordship.
Lawyer is not present.
Yes, court was supposed to appoint like us.
But what about notice on respondent number 2?
Lordship to that, so we have to take instructions. You can Lordship may appoint Michael. Smith.
As this is a jail appeal,
Lordship.
the registry shall process notice to be served on respondent number 2 by handing over the and serve it on respondent number 2 by registered post with AD. Notice is made returnable on so and so. Next para. It is noted that although the name of learned legal aid counsel is reflected in the cause list, but she is not represented She was not present when the matter was previously listed on 29/9/2022 and 27/2/2023. Next, accordingly, the registry shall. We have that list, amicus curiae. Mr. Prasad, we can appoint you as amicus curiae. Not required, Mr. Prasad is there. Accordingly, with consent from Mr. B. Prasad Leonard, counsel who is also in the panel of amicus curiae, is appointed as amicus curiae in the matter. First, the registry shall provide a copy of the paper book to the newly appointed amicus curiae. Next para, having noted that in this matter, the appointed amicus curiae has not appeared consecutively on 3 occasions. Let the registry examine the continuation of examine as to whether the said Leonard amicus curiae is to be continued. Or if any other, if any other learned counsel can be engaged as amicus curiae in lieu of the in her lieu. So let a copy of this order be brought to the notice of the registrar within packet. This should be registered judicial or legal aid council. To the secretary legal aid committee of Guwahati High Court. Next para. Awaiting service of notice list on 22. Service of notice on respond to this transfer and so. We'll give you a copy. But service is not complete. There is a judicial order, but steps was not taken. Item 5. Yes. Mr. Govind and counsel for the amicus legal aid counsel is present. This and Mrs. S. Bharat and APP are present. KCC Jessica service on respond number 2, and the paper book is also prepared and served on both sides. Next, none appears on call for respond number 2. Accordingly, list the matter for hearing in the month of February 2024. Item 6. Yes,
For official agent 12/1.
yes. LCR is received, so paper book is to be prepared. You, Mr. J. Das. Mr. J. Das, counsel for the appellant, and Ms. M. Das, learned AVP for the state, for the respond number 2. For respond number 2, and Ms. S. H. Borat, and APP for respond number 1. First, as per office note dated 12/1/2024, LCR is received. Hence, let the registry prepare a paper book and serve it to the to all the learned appearing counsel. List after 4 weeks awaiting preparation of paper book. Seven. Yes. Yes. So objection is not there. Yes, you can make your submission on merit. You can make your submissions on merit.
There is an IFO page also.
Yes, we are aware of it.
Document kindly give us some time, so we'll file within observation.
Now, have you served notice on the respondent number 2?
That.
This it was provided to you on 17/11/2023. Can you get us information whether it is served on through OC of the concerned police station, Haflong Police Station?
History of us, no?
You wait for some time, we'll take it up at 2 o'clock. You notice served, then we'll hear the IA.
Lordship,
Yes.
can it be on Monday, Lordship?
Monday.
Mon-
Okay. List on
23rd.
22/1/2024, so as to enable is SH Barar and APP to ascertain as to whether notice has been served on respond number two to the jurisdictional police station.
First.
Just before that, you write, Ms. M. Das, counsel for the appellant is present.
Hello, I am appearing Gaelic Council.
As legal aid counsel, okay, legal aid counsel is present, okay.
Right.
It's item 8.
This is an illegal conviction. That's why. I was today that I have come up. However, but I find that the matter is ready for hearing.
Just a moment,
Regulated.
just a moment. No, it's not ready for hearing. The office note says that you have not taken steps for service of notice on respond number 2. This is, I believe, is a POXO matter. Without no service of notice, it can't be heard.
We have to
Pardon me? You'll have to serve notice, you have to take steps. But Mr.
take it back.
A.K. Das, counsel for the appellant, you have changed the appearance.
No longer.
I'm
trying
sorry.
to young.
Huh?
No longer trying to.
No, I'm sorry, I couldn't have forgotten you. A.K. Das, I'm a senior counsel for the appellant, together with assisted by Miss S. Newar, counsel for the appellant, as well as Ms. S.S. Barad and APP for the state. Next para. As per office note dated 1/3/2023, steps were not taken, notice could not be issued. First, accordingly, the instructing counsel for the appellant shall take steps for service of notice on respond number 2 by registered post with ED, as well as an additional process shall be provided to the registry for processing and handing it over to the landed APP for service of service on respond number 2 through the jurisdictional police station. Notice is made returnable on after 5 weeks, 28 to 24. List on so. Mr. Mishra, I am growing old. I couldn't recognize Mr. No, we have a public demand. You'll have to Come back to your old self.
Bit like this. So the management is not, so he said, I saw you as a second lieutenant, and you have become a colonel in no time.
No, but even with that, I could not have missed him. There's item 9. Yes, Mr. Fukan. And- Okay. You have to get information. You have to get information. Can you get it at 2 o'clock? Because what happens is that unless it is listed and a day is wasted.
It's asking for Monday.
Huh?
He's asking for Monday.
For Monday. In fact, we'll record your presence. Only we are requiring that whether it is served or not. Correct. We'll record your presence. Don't worry. I understand that. So that's why. At 2 o'clock, we'll just see if she has record, otherwise it has to be adjourned. But if she can produce the records of service, 1 day is advanced. We'll record your presence. Yes, item 10. Okay.
I'm a big for responding this matter. I've been served with the copy of the appeal memo just today morning.
Oh, is it?
It may come after 4 weeks, my lord. In the
No,
meantime,
it's okay. Okay, then we'll have to adjourn it. Mr. Igayan, counsel is present on behalf of Mr. R.K.D. Chaudhary, standing counsel for the appellant. First of all, Mr. D. Prasad, the counsel for the appellant, has submitted that a copy of the paper book has been served on him only today, and therefore he requires some time to go through it and address the court.
file my objection, my lord. This is
A-
against.
And to file objection if so advised. First of all, according to matters to adjourn today, list after 4 weeks. Okay. Yes, item 12.
This is appeal against Secretary Negotiable Instrument Act. There's a delay of 35 days.
Notice has to be issued. Okay. Mr. B. Sharma, counsel for the applicant. Application under section 5 of the Limitation Act for condonation of delay. Notice. Returnable on Spencer. Steps within 2 days. List on Spencer.
Supply item 19.
May I plead your lordship? Your lordship, this is an appeal against conviction, your lordship. Today the IA has come up. Your lordship, on the last occasion, the prosecution side has taken time to file objection, your lordship.
There's no office note with regard to service. Have you taken steps for service of notice on respond number two?
No.
Have you taken?
Yes.
Oh, no, this is 302.
Yes.
No, I think you'll have to take steps in your, because the service through APP is only for POXO matters. For 302, I think you'll have to take it.
The IA.
No, but you see, without service, we can't be taken up. Correct. Uh, Miss
F.
F. Hussain, counsel for the applicant dash appellant is present. Ms. S. H. Boran and APP shall obtain information as to whether notice on respondent number two was served through the jurisdictional police station.
I think it 302, we're not supposed.
No,
to
no,
use
but
this.
you see, the copies have been, as per the office note, copies have been given to you. Correct. So if it is there, you should have taken
We can
steps.
take a verbal instruction.
Take instructions. So if it's not the next para, having observed that the appellant has been convicted for committing offense under section 302 IPC, the appellant shall also take steps within 2 days for service of notice on respondent number two by registered post with AD. The learned counsel for the appellant dash applicant is permitted to collect postal receipt number from the registry and submit postal track report prior to the next date of listing. Notice is made returnable on so list on the said date.
28.
And in the IA, right, they have this application shall be uh, shall be considered on the service of notice on respondent number two. You collect the postal receipt number and give us postal track report.
As regards filing of the objection in the IA.
She's not made a prayer. I can't write it for myself. No, it's okay. You see, bail matters, objection and all, these are what you call, the court can otherwise deal with it. You may file it, you may not. Item 13.
There's two applicants before your lordship, and both of them were granted bail by this honorable court. They are on bail since 1/10/2018. After the imprisonment. In this case, the appellants were convicted on the basis of circumstantial evidence, and the prime circumstance which the learned trial court relied on is the last seen together.
Correct, because of the fact that you both had gone with a bicycle, two bicycles, and both the bicycles were found at the place of occurrence.
But here your lordship will find that from the evidences.
No, you go by all to say, since you made a statement, I am just taking a reply.
Your lordship will find page 5.
Because if I start from middle, you may miss out many things. Yes, please proceed.
Here, FIR will also be find page 5 and date of occurrence is 28/2/2007. As per FIR, time of occurrence is 8 p.m. FIR was lodged by one Hano Mohan Sokaru, page 5. May I read the FIR? With due respect, I beg to inform you that at about 8 p.m. yesterday, the aforesaid accused persons called my nephew, Sri Omrit Sukharu. So here also that time of taking the decision is 8 p.m. Sukharu from my house, saying that they had some work. So at 8 p.m. When the decision was taken from the informant's house, which shows that at till 8 p.m. the deceased was alive and he was in the house of the informant. Then they killed him on Kahibari College Road and threw his body into the nearby drain. When some local people saw it and made a hue and cry, many people assembled at the place of occurrence. The accused persons fled from the place of occurrence. I therefore pray to you to take necessary steps by investigating into the matter and oblige. The next your lordship will find the evidence of PW1 at page 10. PW1 is Nitai Mondal. I know both the accused persons and I also know that this is Omrit Sukharu. After 4 years ago, about 4 years ago, dead body of Omrit Sukharu was found in a field in Kahibari village. At about 8 p.m., we went to see the dead body and then police came and asked me as to whether I have seen anybody with a disease on that day. I informed the police that I saw both the accused persons along with the deceased person in the afternoon. So here he says afternoon. 2 bicycles were found lying in the place of occurrence. The police seized the same. Exhibit 1 is the seizure list and exhibit 1 by signature cross. I saw the deceased person along with the accused persons at about 4 p.m. So that is why I was pointing out in the FIR, it is said that at 8 p.m. the deceased was alive and was in the house of the informant. In the FIR, it is said at 8 p.m. these 2 persons took it. So here your lordship will find 4. I do not know where they proceeded thereafter. Therefore, a specific question was there because time of in the FIR it is said 8 and he saw at 4. Therefore, a specific question was put to the witness where they were proceeding. He said, I do not know where they proceed thereafter. I saw the seized bicycle lying on the road wherefrom police seized the bicycle. I do not know who kept the bicycle. So, bicycle belongs to whom? It is not there. Last question, I do not know who kept the bicycle. Page 11, PW2. I know the accused persons, but I do not know this is Omrit Sukharu. I cannot exactly say as to the day of occurrence. But few years ago, one of the day, I was sleeping in my house at night. I heard sound outside and came out. And then I saw the person was running through my courtyard and I could identify as Govinda. On the next day morning, I came to know that this is Omrit Sukharu was lying in a pit. Cross. I have not seen who ran away through my courtyard. So in cross, it clarified that he only, out of suspicion, named that appellant. But it cross, he categorically said that he have not seen who ran away through his courtyard. Page 12, PW3. I know this is Rick Sokaru, and I also know the accused persons present in the dock today. Omrit Sokaru expired in the year 2007. While I was coming from Broiler Farm at about 8:30 p.m., I saw two bicycles, one lying on the road, another lying in the field. We called for people, and then we saw some footmarks, and after going ahead, we saw two persons fled away from the pitch. We could not identify the two persons.
What is a pitch?
A pitch that is uh, from road to field, there was some decline road.
What do you call it? Depressed area,
Like the
depressed area.
We called for people, and then we saw some footmark, and after going ahead, we saw two persons fled away from the pitch. We could not identify the two persons. In the light of the torch, we found dead body of Omrit Sokaru. We saw the injury on the penis of the deceased person, and his neck was tied with belt. Cross. I have not stated about the sustained injury before the police. PW 4, page 30. I know both the accused persons and I also know the deceased person. The place of occurrence is nearby Bosti land. In the year 2007, one night, my son Manjit Kolita informed me after returning home at night at about 8:30 p.m. that he saw two persons fled away near the pitch of our house, and one person was lying dead in the pitch. Cross decline. Page 14, PW 5. I know both the accused persons and I also know the deceased person. About 2 years ago, Omrit Sokaru expired. My house situated at a distance about 1 kilometer. After hearing hue and cry, I along with some villagers proceeded towards the place where from sound was coming. We found one dead body lying in the pitch. Exhibit 2 is the inquest report and Exhibit 2.1 is my signature. Police seized two bicycles, all from the place of occurrence. I also put my signature thereon. Exhibit 1 is the seizure list and Exhibit 1.1 is my signature. I have heard from the villagers that deceased and two accused persons were proceeding on bicycle on the day of the occurrence. I was reported by Nitai Mandal about the fact that the accused person went with the deceased in two bicycles. So here he was, here said witness, also this witness, and he heard from Nitai Mandal, who said that deceased and the appellants were seen at 4 p.m. Now PW 6, page 15. I know accused Punya Majumdar and do not know other accused. About 5-6 years ago, one day morning, came to know that one person lying dead at Kahibari near a college. I do not know the deceased person or as to how the person died. Cross decline. Re-examination by prosecution. I was present while police recorded the statement of accused Punya Majumdar in presence of executive magistrate. Exhibit 3 is the statement. Exhibit 3.1 is my signature. Here just just one thing I'm pointing out to your lordship, that regarding this part, that statement was recorded by police in presence of magistrate. The learned trial court, relying on the full bench judgment of our High Court lordship, had held that this has no evidentiary value. But subsequently, this circumstance was taken into consideration while convicting the appellant. At paragraph 31 of the impugned judgment, full bench judgment of our High Court was read. Cross. I myself did not read the statement. Exhibit 3, I could not remember as to who recorded the statement, nor I can say how as to whether it was read over to me. Perhaps I was there. Witness is shaky about his statement. Again, he stated that I was not present at the time of recording the statement. Now, page 17, PW7. Is declared hostile. I know the accused person in the dock. The deceased Amrit Sokaru also known to me. About 4-5 years back, one day I heard that Amrit Sokaru has been killed and there was halla in our village. I came out from the house and came to know that Amrit Sokaru has been killed. Declared hostile at this stage. Of the prosecution. It is not a fact that I stated before police that after coming out from my house at about 8:30 p.m., I saw Govinda Mandal and Punyo alias Ranjit run through the cultivation with clay on their body and found through our road. And after some time, I came to know that said two persons has killed Amrit Sokaru. Cross-examination. There was huge gathering of people in the village. It was about 8:39 p.m. which incident took place. I know village people who gathered at the time of incident, but I did not see accused persons at that time. I do not know when police came at the time of occurrence. The statement referred by prosecution as above was not stated by me and has been written by police on their own, of their own. I have no knowledge about involvement of accused with the occurrence, nor I have seen them. W8, page 19, he was also declared hostile. I know both accused persons. I also know the deceased Amrit Sokaru. About 5 years ago, at about 7 p.m., I was giving water in cultivation. Then somebody made hue and cry, thief, thief. Then I saw one person running through my paddy field and I thought he may be a thief. After I came to home, I came to know that one person died in the road, namely Megha, alias Amrit. So he speaks about one person. I could not identify the person who ran through my paddy field. Police did not take my statement, declared hostile by prosecution. It is not a fact that I stated before police that two accused persons, Govinda and Punya, came running with mud on the body and arrived in our courtyard. And as I asked them as to why they are running, then ran through, they replied that son of so had been killed them, had tried to kill them. Later on, I came to know from people that 3 accused persons had been killed Amrit. So now 3 persons. It is not a fact that today I have given false evidence only to save our local boys out of favor. Cross-examination. Police has not meet him nor took my statement. At the time of hearing halla, etc., I was not in my house. If police has recorded my statement to the effect that I was present in my house, then it will be false. I gave no statement before police as stated by prosecution, and it is written of their own, and it is false. I cannot say from whom I heard that accused person has killed the accused. Now PW9. PW9 is a circle officer. On 3/3/2007, I was working as a circle officer at Samoria Revenue Circle. On that day, statement of Govinda Mandal, son of Biren Mandal, was recorded by SI Sadananda Sharma at Samoria OP in my presence, and I put my signature on the statement recorded by SI Sadananda Sharma. Exhibit 4 is the statement of Govinda Mandal and Exhibit 4.1 is my signature. Statement of another accused Punya Majumdar was also recorded in my presence, while Exhibit 3 is the statement of Punya Majumdar and Exhibit 3-2 is my signature. Cross-examination. The contents of exhibit 3 and 4 were written by SI Sadananda Sharma in my office. I do not know how to record the extrajudicial confession. I signed the exhibit 3 and 4 as witness. There is no signature of accused Govinda Mondal in exhibit 4. I do not remember whether the signature of accused was taken in my presence or not. It is not a fact that exhibit 3 and 4 were not legally admissible. Page 22 is the evidence of informant. I know the accused persons.
No, sir, after the name.
I also
Identify criminal.
Yes,
page 22. I know the accused person. I also knew the deceased Omri. The deceased was the son of my elder brother. He died in the year 2007. I was at my residence at the time of occurrence at about 4 p.m. On the date of occurrence, both the accused persons called out Omri from his house. I was present in the house at that time. There is college situated away from our house. I heard Halla near the college about 7 p.m. on the date of occurrence. After hearing Halla, I rushed to the place of origin of Halla, that is near the college, and there I heard that Amrit was murdered. On being asked, I told the people gathered there at about 4 p.m. The accused persons were with the deceased. So here your lordship will find that now he come down to 4 p.m. Initially, he said in the FIR that at 8 p.m. the appellants took the deceased from his house. The deceased was found dead by the side of the village road at Kahibari. The dead body was in the drain by the side of road. The college I referred to above and the place of occurrence are adjacent. The villagers searched for both the accused person but cannot find them. The FIR was lodged by me. FIR was written by one Niranjan Das as per my version and was also read over to me, after which I put my signature. I am familiar with the signature of the scribe Niranjan Das signature cross. I read up to class 6. I have submitted in the FIR that the accused persons called out the deceased at about 8 p.m. on the date of occurrence. Although I have stated in my evidence on oath that the deceased was called out by the accused person at about 4 p.m. The statement given on oath in the court today that the accused persons called out the deceased at 4 p.m. is true. I do not remember stating to the police that at 8 p.m. on the date of occurrence, the deceased came to my house and then he was called out by both the accused persons. I did not state before police that after hearing Halla at 7 p.m., I went near the college, that is place of origin of the Halla, and on being asked, told people gathered was that about 4 p.m. on that day itself, the deceased was called out by the accused persons. Here also, your lordship find that he is speaking about Halla at 7 p.m. and other witnesses said about 8:30 p.m. So there is also doubt regarding seeing the appellants at that point of time, because if they are actually the assailant, they would not have waited for 7 to the 8:30 or 8 for about 1 hour after killing the deceased. This fact I did not narrate in the FIR. I am not with the witness to the murder of the deceased. The house of mine and that of the accused is intervened by distance of about 5 bighas of land. It is not a fact that the place of occurrence is at distance about 4 kilometers from my house. My wife also knew that the accused persons called out the deceased from my house. I did not state this fact to the police. It is not a fact that the accused persons did not call out the deceased from my house as I stated. It is not a fact that the FIR is lodged in this case against the accused persons only on suspicion. It is not a fact that I sent to the police of origin of the Halla near the college. This is a similar distance away from my house, and that there only I heard that the deceased was killed are all false. Now, PW11 who conducted postmortem found ligature mark which was homicidal. Opinion part, your lordship will find page 25. As per my opinion, the death was due to asphyxia resulting from antemortem ligature, strangulation, and homicidal in nature. Approximate time since death 12 to 24 hours is my report wherein, which is for this. 26, your lordship will find statement of Gorita doctor. Is the IO. On 16/6/2007, I was working as in charge Somaria under Boko Police Station, and on that day, the OC Boko Police Station re-enrolls the case diary of this case, and then I have gone through the case diary and I have collected the postmortem report. I have submitted the charge sheet against the arrested accused person under section 302 of IPC. Exhibit 8 is the charge sheet and Exhibit 8(1) is my signature. Cross-examination. Prior to submission of the charge sheet, approval of additional SP. Page 27. On 16/6/2007, I was posted at Somaria PP. I received the case diary on 16/6/2007 as endorsed by the OC to complete the investigation. The predecessor IO SI Sadananda Sharma had already been expired. As per the case diary, Sadananda Sharma investigated the case from the date of occurrence. The FIR was lodged by one Hanumohan Sokharu. Exhibit 5 is the said Ajahar. Exhibit 5(4) and 5(5) are the signatures of Sadananda Sharma, which I know. Exhibit 9 is the printed form of FIR. Exhibit 9(1) is the signature of then OC of Boko PS. He visited the place of occurrence, examined the witnesses and prepared sketch map. Exhibit 10 is the sketch map prepared by Sadananda Sharma. Is his signature. He had done in inquest over the dead body. Exhibit 2 is the inquest report, and Exhibit 2(4) is the signature of Sadananda Sharma, which I know. During investigation, the accused Punyo Mujumdar was produced by IO before executive magistrate named Dasarath Das of Somaria. revenue circle, where the accused made extrajudicial confessional statement. Exhibit 3 is the said statement recorded on 10/3/2007. And Exhibit 3 is the signature of the IO Sadananda Sharma. Accused Punya Majumdar signed on the said confessional statement, which is Exhibit 3-4. Exhibit 4 is the extrajudicial confessional statement made by the accused Govinda Mondal, recorded on 3/3/2007. And Exhibit 4 is the signature of IO. The IO during investigation seized 2 numbers of bicycles, while Exhibit 1 and Exhibit 1-3 is the signature of IO Sadananda Sharma, which I know. During investigation, the previous IO Sadananda Sharma sent the dead body for postmortem examination. Exhibit 7 is the dead body challan. Exhibit 7-2 is the signature of Sadananda Sharma, which I know. Thereafter, on transfer of the previous IO, I received the case diary. From the case diary, I found that during investigation, the previous IO examined one witness, namely Jantu Biswas. The witness made a statement before the earlier IO that 2 accused persons, Govinda Mondal, came running with mud on their body and arrived in our courtyard. And as I asked them as to why they are running, then they ran through. They replied that some people were chasing them to kill them. He further stated before IO that these 2 boys have killed Amrit. Exhibit 11 is the said statement. Exhibit 11-1 is the signature of IO Sadananda Sharma, which I know. On the basis of investigation already done and after taking over the charge of the case, I completed the investigation and submitted charge sheet against the accused, crossed by defense. I have not examined any witness nor I visited the place of occurrence. 2 bicycles were seized by the previous IO, but ownership of the bicycle has not been ascertained. Apart from the bicycle, no other articles were seized from the place of occurrence to substantiate the fact that accused persons were involved. So apart from bicycle, there is no other material. I do not know the distance of the place of occurrence from the house of the accused. The incident took place on 28/2/2007. An FIR was lodged on 1/3/2007. Before receiving the FIR, there was a preliminary inquiry as per MCD, miscellaneous case diary. Time of calling the deceased by the accused has been recorded as 8 p.m. The exact time of killing is not recorded in the FIR. While PW10 was examined by the previous IO, and he made a same statement that deceased was called on by the accused at around 8 p.m. and thereafter he was killed and laid down in a drain near the college road. So this is confirmed through IO. I do not know the distance of the residence of PW2 Chintamani Mondal from the place of occurrence. I also have no idea about the distance of residence of PW4 from the place of occurrence. One person, namely Niranjan Das, is shown as a witness in the extrajudicial confessional statement made by the accused. But there is no such note on case diary, and as such, I cannot say where from he was brought by the IO to put his signature on the statement made by the accused. I cannot say at what distance from the place of occurrence the house of PW7 Jiten Mondal is situated, and on the case diary, I find no such note as to state that wherefrom this witness was called by the IO to appear as a witness in the confessional statement. It is not a fact that previous IO have not examined PW6, 7 and 8 during investigation under section 161 CRPC. The statements which were called as extrajudicial confessional statement recorded by the previous IO Sadananda Sharma, it was recorded in presence of the executive magistrate. In the statement recorded on 03/03/2007, have no attaching witness, but on statement recorded on 10/3/2007 contains name of witnesses Niranjan Das and Mohan Bayan.
The witnesses shown on Exhibit 3, namely Mohat Bayon, was not examined as a witness under Section 161 CRPC as revealed from the case diary. During examination of the case diary and investigation, I found no eyewitness of the occurrence. It is not a fact that charge sheet is submitted without proper investigation and application of mind. Now, those circumstances which are relied on by the trial court while convicting the appellants, your lordship will find at page 59 of the paper book and paragraph 41 of the judgment. Yes, Lord. Paragraph 41. May I read it? Considering the arguments placed by the parties to the proceeding, I have carefully scrutinized the evidence as already discussed and found the sequence of happenings which have been established by the prosecution witnesses as below. It was around 4 p.m. in the evening. Both the accused came to the house of Sonu Mohan Sokaru, the uncle of the deceased, and called out the deceased with him. On that day, a co-villager saw both of the accused along with the deceased in the afternoon on the date when the dead body of Amrit Sokaru was found in a pit at Kahibari village at around 8 p.m. One of the co-villagers, a woman of the neighboring area, PW2, heard noise outside and saw a person running through her courtyard at the time of incident and initially claimed that he was accused Govindo. So initially claimed, subsequently said, I have not seen. Some of the villagers saw two bicycles on that fateful evening lying on the road and in the field which were seized by police. The villagers detected the dead body of Amrit Sokaru near the college from a pit. So ownership of bicycles are not proved. One of the co-villagers heard from the villagers that deceased and two accused persons were seen proceeding on two bicycles on the date of occurrence, which infers that no bicycle was there with the deceased and he was carrying by the accused in their bicycle. So inference cannot be there in the case of circumstantial evidence. The circumstances which are relied on by the prosecution have to be proved circumstances. Number 5, the accused persons were produced at the police station and the statements were recorded by police in presence of executive magistrate and also in presence of prosecution witness PW6. The accused persons were arrested. So regarding this circumstance, I will place paragraph 31 of the impugned judgment itself. The postmortem report of the deceased was collected and on completion of investigation, police submitted charge sheet against the accused under section 302/34 of IPC. So these are the circumstances relied on by the trial court. And in my humble submission, these circumstances nowhere point towards the guilt of the appellants. Paragraph 31 of the impugned judgment at page 52, your lordship will find regarding that reference regarding full bench judgment of our High Court. There was conflicting views regarding that statement recording by the circle officer. And therefore matter was referred to full bench. Para 31, page 52. Page 52 of the paper book. In para 30, your lordship will find that discussion regarding that exhibit 3 and 4, that is confessional statements, and thereafter para 31. And after discussing that full bench judgment lordship, that your lordship will find page paragraph 33, page 54 of the paper book, the learned trial court finding of the learned trial court. In view of the above proposition of law.
Just one. Para 33.
Yes. In view of the above position of law, the statement recorded by the investigating officer erroneously in course of investigation in presence of an executive magistrate is not legally admissible and considered not the evidence implicating the accused persons. If it is not legally admissible, that circumstance even cannot be taken to convict the accused.
Please repeat again. You are saying that statement, if it is not legally admissible, then
Cannot be taken into consideration while convicting the appellant on the basis of circumstantial evidence. Here, these are the circumstances which are against the appellants. Now, my submission before lordship is that the from plain reading of the evidence adduced by the prosecution side, lordship, the circumstances which call out do not conclusively prove the guilt of the appellants, lordship. Here in this regard, just I am handed over one judgment of our High Court, lordship. Here at paragraph, I'm relying on 45, 46, and 51. Paragraph 44, lordship, that Sharad Bindichan, that was
paragraphs.
paragraph 45, 46, and 51.
Yes.
Paragraph 45, your lordship will find that concealed, lordship, with that 5 golden principles. Your lordship is aware, but still for reading, may I read?
Yes, please.
A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. Number 1, the circumstances from which the conclusion of guilt is to be drawn should be fully established. So here I am stressing on fully established because here your lordship has seen that the time of taking away of the decision is stated differently. During FIR and during investigation, they said 8 p.m. and subsequently while deposing before the court, they say 4 p.m. It may be noted, and that discrepancy is serious because lordship that if it is accepted that at 8 p.m. they have taken, then till 8 p.m. he was alive. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji Sabarao Bobde, State of Maharashtra. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict. And the mental distance between may be and must be is long and divides broad conjectures from sure conclusions.
Mr. Ahmed, please, there's only one more factor. You see, apart from the time, somebody says 4, somebody says 7, somebody says 8 or 8:30. Now, it is a fact that the witnesses were very clear that they have seen you. One of the accused, Govinda, that he was seen at one point of time. After that, his dead body is found. Now, the Supreme Court has also interpreted the words immediately, proximity of time. So it is not with arithmetical precision that the last seen theory must always show that within the proximal time of the death he was last seen. So if it can be established that he was last seen in your presence, notwithstanding time lag, but it is your circumstances to show that it was not there. Because last seen theory, what happened thereafter is something which is 106, you will have to show. That okay, last seen at 4 p.m. After 4 p.m. what? After 4 p.m. I left him at 5 p.m. So that evidence is also not there.
Says Judge Lordship, which says Lordship that even if your last seen theory is proved, then also it alone is not sufficient to convict the
No, there you are right. There you are right.
absence of other. The facts so established should be consistent with, only with the hypothesis of the guilt of the accused. That is to say that they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. Paragraph 46. Thus, it may be seen that Honorable Apex Court has held that the circumstances from which the conclusion of guilt is to be drawn should be fully established. It is also held that the said circumstances must or should and not may be established. It is also a settled principle of law that however strong a suspicion may be, it cannot take place of proof beyond reasonable doubt in a criminal trial. In the light of the said principle, let us know. So this is there. And paragraph 51, Lordship, although I have referred, but I am not reading at this stage, because already I have placed for Lordship that full court judgment is there. And this paragraph 51 is in tune with that full court judgment. And next I am just relying to 2023 7 SEC. I have given the book list.
Seven SCC? No,
Page
so 7 SCC, 7 to 7.
Yes.
7 to 7. Correct.
Paragraph 15 to 18 and paragraph 20. 15 to 18 is similar to what I have already read from your lordship.
This is where you want to view that? You want to view that citation? Yes.
Paragraph 15 to 18 is in similar to with, what I have already read from our High Court judgment lordship, that sir, Bidichan is discussed, and thereafter must and should, that is discussed lordship. So I am not reading again lordship. That part may be skipped, and lordship may kindly turn to paragraph 22.
22.
Yes.
Yes.
The law with regard to extrajudicial confession has been exclusively discussed in Munna Kumar Upadhyay versus State of Andhra Pradesh, wherein this court has also referred to its earlier judgment, which read thus. This court has had the occasion to discuss the effect of extrajudicial confession in a number of decisions. In Balwinder Singh versus State of Punjab, this court stated the principle that an extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with a great deal of care and caution. Where an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses importance. So this judgment I am referring because also that the confessional statement is treated here as to be extrajudicial confession. Therefore, I am placing this. And then I'm referring to lordship that 2016 12 SEC paragraph page 251.
2016,
12
12 SCC
251.
251.
Paragraph 12. It is right law that a conviction cannot be recorded against the accused merely on the ground that the accused was last seen with the deceased. In other words, a conviction cannot be based on the only circumstance of last seen together. Normally, last seen theory comes into play where the time gap between the point of time when the accused and the deceased were last seen alive and when the deceased is found dead is so small that possibility of any person other than the accused being the perpetrator of the crime becomes impossible. To record a conviction, the last seen together itself would not be sufficient, and the prosecution has to complete the chain of circumstances to bring home the guilt of the accused. And here also your lordship has seen that it would take that 4 p.m. the appellants were seen along with the deceased. Then also in the affair it is alleged that which was lost at the initial point of time that at 8 p.m. the deceased left the house. Whether with accused or alone, that is will be decided by your lordship. At 8 p.m. he was alive and he was in the house of the informant. And then I'm going on with 2020 volume 3 GLT 151.
Twenty 20,
Page
volume 2, GLT 151.
paragraph 20.
I'm telling him. I'm telling my court master, otherwise he's typing it out. No, it's notifications are with. Otherwise, he has to go back, find out your chat, and then find out. So I'm assisting him. Yes.
Again, in the case of Kanhaiya Lal, versus State of Rajasthan reported in so the Honorable Supreme Court held that circumstance of last seen together does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant by itself cannot lead to proof of guilt against the accused. Here in this case, except that last seen theory, that also doubtful because that one said at 4 p.m., one said at 8 p.m. So it is not conclusively true. And as I have claimed to Lordship that Sharad Birdichan, it is said that when a circumstance, a circumstance must be fully true. But here it is not true.
No, can it not be read in a different way? You see, witness number 1 says that he saw at 4 p.m. The other witness says that 8 p.m. So that means for 4 hours they are together. Can't we take that view? You see, it's not necessary that everybody must have seen him at the same point of time. There are two different time points. So if the deceased is seen with the accused at 4 p.m. and then at 8 p.m. would mean that 4 hours they are together.
I have cleared a subsequent Lordship is I'm agreeing with Lordship. At 4 p.m. they were seen together. Even if we assume that it is correct, then at 8 p.m. again they were seen. So my submission before Lordship is that 4 p.m. to 8 p.m. the deceased was alive. Nothing happened to him. So that part, that 4 p.m. they were seen, that cannot be taken into consideration. So that part has to be excluded. Now prosecution have to prove that whether the deceased were actually taken by the appellants had actually taken the appellant at 8 p.m. or not. Now regarding this, there is conflicting because in the evidence, what the other witnesses say that at 7 p.m. he heard Halla and 4 p.m. he was taken. So that 4 p.m. and 8 p.m. he again disputing the same fact. From the affair, what my submission before your Lordship is that till 8 p.m. he was alive.
No, there's another theory. If you have one watch, you are certain of the time. But if there are 3 watches, you can't be certain of the time. But there is every possibility that this watch at your back and the one in your front may not be giving the exact time. Although we have a timekeeper here, but it is quite possible that these 2 times may not match. There's a third watch in my chamber. So at times when I come out from the chamber and I reach the courtroom, I find that I am 2 minutes late, where I was started on time. Correct. So if you have one watch, you are certain of the time. But if you have more than one watch, you will not be certain of the time.
That
It's a theory which I can demonstrate here only in the courtroom.
that will help my case because if there are 2 views, Lordship, then benefit will go to the appellant.
Benefit will go to your accused. Yes.
So point regarding lordship 8 p.m. and 4 p.m. Actually, the original FIR is written as 8 p.m. your lordship. And I should not see the case record for satisfaction we have seen, my lord. But it is written as 8 p.m. Lordship to the proximity of time when the accused is last.
So this Assamese 8 was written as English 4.
But this persons were last seen with the deceased and proximity of time is very, very late, my lord. Immediately after he was taken away from his residence, and which is a FIR case, your lordship, which is the case related to the FIR, your lordship. So lordship, time period is very late. So lordship, the the presence of accused person. is
Just,
also-
just a moment. Has this aspect been dealt with by the learned trial court? That the, as per the FIR, it was, what was the time? The, its finding. Because you see in paragraph 34 of the judgment, there is a reference to 7 p.m. and 4 p.m. Sorry, the 4, 7 and 8 p.m. in paragraph 34.
Clarification.
That in FIR it has mentioned about 8 p.m. But the same informant while deposing before the court.
34.
No. Moreover, Mr. Ahmed has also referred to page 23, cross-examination. He has specifically stated that he was put a question that the incident was of 8 p.m. He says no, 4 p.m. So therefore, he stands by 4 p.m. So if it is 4 p.m., then this we will have to accept his submission that the last seen theory for the first part that goes, only last part remains. That 4 p.m. goes. Because now it will be the last point of time, that is 8 p.m. That is what his submissions are. that if there are two time lag.
That is like law.
No, he's saying that if there's two time period. Let us say that A and B have gone to a movie. So a witness Z saw him in the line in the cinema hall at 2 p.m. purchasing ticket for the 2 p.m. show. People see him coming out at 5 p.m. So therefore, you see the first point of time when he entered the cinema hall, that is irrelevant because last in theory will start from 5 p.m. when you saw him coming out of the cinema hall. That is what if I understand from your submission. So therefore, first part goes. So therefore, it's not a question of he's trying to convince us that from 2 p.m. to 5 p.m., even if they are together, the starting point of time would be 5 p.m. if they are going to a movie and coming out, if that is the situation.
That their discrepancy as to the timing part, but other witnesses are beware, this accused person last thing, they were, even the other witness, my lord, PW2, we saw the Govinda running away. He could not identify the other person. Then PW3 says, my lord, saw two accused persons fled away from the page, my lord. And your lordship, incidentally, these witnesses have identified the accused person. There's dog identification. They have identified them. You know, they are the persons who were, and they identified. It's not that somebody else was there. Lordship, and it's not their case, your lordship, that they were not there with the accused person. They did not. Although in Trivati they say they were not there, but there is not, they could not establish it by way of bringing in defense witness like that. Where was clear, but at the time of occurrence, my lord.
No, that is not required to prove.
There are judgments, my lord, where I am handicapped, I didn't have so. So if they are found, they were with the company of the victim, they have to, give evidence to the effect that when, at what time they have left the company. Of this is my lord.
No, just a moment. Somebody saw them running out. Correct. She is not a witness to both of them seen together.
Yes.
Correct. So you see, if somebody saw a dead body and is running away, doesn't prove that he is the murderer. You saw somebody running away.
Coupled with the evidence of.
Running away may be an independent act. Somebody is running away. Not necessarily that he is murdered and running away, not necessarily that he has seen the dead body and running away.
Evidence of PW 1 and 10. If your lordship considers that the accused persons were there with the deceased at 2 p.m., within about 8 p.m. incident, 4 p.m. accused called the deceased. Lordship proves that they called the deceased as to why did they call? There's no explanation from them. And when they have partaked the company of the deceased, that is not there.
Okay.
One more aspect, your lordship.
You continue to.
instructed me to appear, but I could not appear in time, so an order was passed.
But we have already signed and we have released that file.
I came late. a bit late.
We've already signed this. Signatures, in fact, has been passed and has been released. And see what can be done. Because this is the third day of default.
Last.
No, you see, there are difficulties with us. Number one, there is a mandate of the Supreme Court that in cases where there is life sentence or death reference, or when POCSO matters are there, we are mandatorily required to take the assistance of a legal aid counsel. And if the legal aid counsel is not there, this has led to 3 adjournments of the council, legal aid counsel not being there. But if somebody takes a brief, you see, whatever be there, but there are, you see, everybody has a friend who can make a mention at the appropriate time. But if matters are adjourned just because of that, the counsel is not there. And then to be a legal aid counsel. That's why we passed an order. We said that the registry will examine whether it has to be continued or not. Because if counsel are there, the briefs are not being returned. And incidentally, I am on the administrative side, I am in charge of legal aid cell in this court. So everything comes to me, it falls back to me. I have to take administrative call on this panel. In fact, last time when I was taking up these criminal matters, I requested Ms. Bhuya and others to see if all the what you call legal aid counsel are effectively doing their. We tried to do a private survey.
She filed
Uh,
a bail petition and others, but due to her mother's illness, she went away and she informed me in the morning itself. Except I got late. I could not reach in time.
That was item number.
Four.
Oh, so say later on in the post-lunch session, Mr. S.N. Tamuli, learned counsel, had made a mention that the learned legal aid counsel had gone to her hometown for the treatment of her ailing mother. And though he was instructed to pray for an adjournment, he was late in reaching the court. His submission is noted. List as before. Yes, yes. It was served. There were 2 items. In item number 4.
He
3.
also instructed the sort.
Okay.
Right, that they don't see concerns of leadership of the-
Okay.
So we take the-
We'll take Wednesday or Friday next.
How to write letters to the consultant.
Correct. So when do you want?
Send
2 weeks time in item number 3. But it has been, you are informed that it has been served.
me what has been said. Item four.
Oh, item 4, item 3. Okay, item 3. Okay. Okay. Okay.
It's an
In item, bail application. Item 3.
I'm agreeing to her, but the date may be fixed.
Okay.
Very good.
Mr. Y.S. Manan, counsel for the applicant. Mr. S.H. Borat under the APP has submitted that she could not obtain information as to whether notice was served on the respondent number 2 to the officer in charge of the concerned police station, and she prays for some time for information. So prayer is allowed. Let the information be procured in the meantime. Next file list on. Choose a date. There's a calendar in front of you. Mr. Manan, comfortable with that date? 3/01/2024. And item 4.
Item 9 to time being হয়েছিল।
Item 4, A2.
এটা যে মাত্র দেওয়ার জন্য করেছে।
No, not 4. In item 4, notice was served. But then item 4 of that goes, Ms. the APP has informed that notice has been served on the respondent to through the jurisdictional police station. Hold the body. Okay. Item 4.
I think right. Can you give us some time, right, related to the concern?
Item 9. Okay. Mr. R. Fukan, counsel for the legal aid counsel for the appellant. Mr. SH Baral and APP prays for some time to obtain instructions as to whether notice has been served on the respondent number 2 through jurisdictional police station. First of prayer is allowed. The necessary information may be collected in the meantime. List on same day, 30 January 2024. 13. No, 13 is the hearing. Item 7. Okay. Ms. M. Das, counsel for the legal aid counsel for the appellant. Same submission, 30 January 2024. Okay.
Already have taken view of any time, there's nothing.
Just on. Basi. Yes, last in theory.
Although they have taken plea of alibi, there's nothing, they could not bring any witness to the reference as to where they was at the time of occurrence, lordship. And your lordship, they have not taken any plea, your lordship, and what time they have left the company of the deceased, my lord. One more aspect, your lordship, extrajudicial confession.
Sorry, we are missing out the point. Plea of alibi has somebody taken?
313. They say they were not there.
No, they were not there. It's okay, but that's not a plea of alibi. Plea of alibi is that he has to give a certain statement, because in the Evidence Act, you will find that he was in Calcutta, he was in Lahore,
Yeah, but
that example
but
is
they were
given.
not there, that is there in 313, but they did not bring any witness to that effect or bring any evidence to that effect, defense witness, to substantiate the plea. They were
No,
not
but
there.
whether saying that I was not there is a plea of alibi. Clearly, plea of alibi would be that he is setting up a case that he was on that day, particular time, he was in Calcutta. And he produces a, what you call,
Not
something, but
substantiate,
merely saying that
although
I'm
he
not there.
taken that plea, there's nothing to substantiate that plea, my lord. That plea that he was not there. He was not there. Lordship, may kindly have a look at the 313 statements once, my lord.
No, I was not there.
Yes,
So I was not there
I
is
do not
a,
know about the Bible,
is
I do
merely a
not-
defense
yes.
that he is not there. But
I
whether
was
it-
somewhere else, that plea he has not taken. But he was not there, that plea he was taken, he has taken. my lord.
No, that is a simple denial.
Denial, maybe it can be taken as a denial. Lordship, apart from that, your lordship, extrajudicial confession part, although the learned trial court has not taken into account, lordship, any statement made before the police is barred by section 25 of the Evidence Act. Since lordship, may I make a submission to that effect, since it was given before the circle officer who was deposed before the court below, your lordship, and he was added as a witness, SPW 9, my lord. Lordship, it may be admissible, although the police officer, we just recorded it. The circle officer who was there, who has been added with PW 9. He was there. In his presence, in his chamber, it was recorded. Police officer, maybe it was written by police officer, but lordship, it may not be barred by section 25. I may be wrong, my lord, but I am making that submission.
Well, see, when you are not fully having a conviction, then to make an argument and throw the ball to the court to deal with it, that is something more dangerous.
I don't have any case, I don't find it there. Lordship, not fixing the police officer not to be proved, my lord, it's clear, section 25. But since it was given before the circle officer,
No, you see, there are two things which is very discomfortable. Number one, he's a magistrate.
it's
He says that he does not know how to write confession, extrajudicial confession. That is one part. But he could not take an assistance of the police officer to do it, because presence of a police officer itself vitiates the recording of a statement.
it was,
So-
but circle officer, since he was present there, and the police officer only wrote it down, my lord.
No, but he couldn't have. The magistrate cannot abdicate his work to the police officer. It'll be almost like, you see, let us assume, I'm good in giving bad examples, horrible examples. I'm giving you one. You see, let us assume that my secretary, she is a LLB graduate. She is hearing it intently, whatever you are arguing, and along with me, she is also hearing it, because she can't close her ears. So she is hearing it. Now, can we think of a situation such that she will say that, okay, my lord, you have heard it, I have also heard it. Now I'll draft a judgment and you just read it.
One
She's
is
capable of doing it,
signature.
because we have worked with stenographers in this court who have drafted what you call, they are very good in drafting the language. I'll not say the names, but there are a few honorable judges in whose orders you will not find a single mistake of even a comma or full stop.
Lordship, it pays 69. I'm making the submission because I don't find.
No, because I have to deal with it. You
Lordship,
see, making
above
submission is one thing.
My lord, above statement has been recorded in my presence and his, put his signature, circle
No, in
officer.
just a lighter tone, I'm not accusing you of anything, but in a lighter tone. Few days back, in the courtroom, for making a submission which was not legal, I had imposed a cost of 20,000 on the lawyer. The the learned lawyer, I am informed because the order has come to me. The lawyer has gone against that order before the Supreme Court of India. And the Supreme Court of India said that, well, if he apologizes, you will reconsider the order. It's in a lighter tone, I'm not saying that. But you see, a submission, you'll have to deal with it. Please also try to understand that. Merely making a plea and when we take it as a plea, record it in our notes, then we'll have to deal with it.
Not sure. But
So-
that if I have to, if I can bring some citations, I have to find out, my lord, because on record, it has come up on evidence, PW9, he was the circle officer, and in his lordship, extrajudicial confession, his exhibited piece of document, he has written that it was given in his presence, and in his deposition, he said in his chamber. it
But
was
that is
recorded.
repeated. You see, there's no judgment. I have not come across any judgment which says if a statement is recorded by a police officer at the dictation of an executive magistrate, it becomes valid.
That was not.
His presence itself. There are
presence.
judgments which also say that his mere presence in the room or outside the room, that also vitiates because that discloses the presence of a police officer in the vicinity which is threatening to the witness. So the courts have interpreted it in that manner. Even our courts have said that in recording of a,
And even otherwise.
what is that
your lordship-
judgment? Wherein, where while recording a statement, a police officer came inside the courtroom and went away.
There are judgments.
He-
2017 5GL.
The police officer came in the room and then went away, 2017. Because this is our court judgment.
Even if your lordship takes into account extrajudicial confession part, it's a very big piece of evidence, my lord. But my submission is that I'm just trying to make a submission, my lord, because it was given in presence of a circle officer. And
No, we rather we would expect fairness. You see, prosecutor does not mean that he has to prosecute everything. Because you see, there's a change in role. Number one, when you are addressing the court, and this is something which I have learned, Mr. Mishra is there. He's my guru on this point. You see, the point which I have learned from him was that when a counsel is making the submission before the court, he is acting as an officer of the court, and therefore
your lordship,
some sort of fairness must be there, number one. Number two, there is another way of putting things into a perspective, which of course he did not say, but we have learned from him, that the demeanor of the lawyer in addressing the court will explain it to the court that he is not very strongly making that statement. So it is for the court to.
Submission, because I don't find any other material.
No, it is not there. In fact, it is not there. It
I'm
is not
trying to
there.
Make a submission, my lord, it may be, because you know, whatever they have stated in the extrajudicial confession, substantiate the post-mortem report, my lord. The manner of injury received by the deceased on his
Because
knee.
that is how we learned that because you see, I must confess, is there when I'm addressing it, I'm saying it with full responsibility. You see, I'm saying in a lighter tone. I'm not accusing you. Please don't take it as I'm making a comment on you. But you see, just in a because through you I can express to others also. At times, when we know about the credibility of the learned counsel or senior counsel addressing us, we don't even have to open the book or the what you call file, because we know that what he's saying is gospel truth. That amount of confidence we have on selected few. No, I'm not saying him because I'm not pointing out. I'm saying that I have learned from him. I do not, what you call, I am not certifying that he does so, but I learned it from him. I'm not certifying anyone, but you see, this is something we have been groomed up with it. And I would be happy if that is followed, because our bar in Guwahati is known for its demeanor in the courtroom. I have visited many courts in the country, but I can say with some amount of proud feeling that The demeanor of the lawyers in this bar is one of the best.
I don't have any other submissions to make except whatever is before me, your lordship. Today I didn't have.
No, it's
paper
okay,
book
it's
also.
okay.
I've collected from my learned friend.
Okay, okay.
It's a big for
No, no, it's
informal.
okay. I'm not accusing you. Please don't take it that
Lordship.
I'm mentioning the
Yeah.
comment.
Because my duty is to lordship, so that no innocent person is convicted and no lordship accused person is lordship released, my lord, scot free.
Because it is two things. Number one, from his submission, which we have gathered is, number one, although there is a slight reference to the lasting theory, but the fact is that except for the lasting theory, he has not been connected with any crime. You see, number one, there are two or three things. He was strangulated with a belt. The ownership of the belt is not known. The police did not make any forensic examination of the belt to find out whether he's been that was the weapon of strangulation and whose belt it was. There is no proof. Number one. Number two, the for in a circumstantial evidence, the one of the requirements is that there should be a motive attributed. There must be something to connect it with the motive. If the motive is not there, there are again judgments which say that the circumstantial evidence, though weak, with the lack of motive, it fails. That is the second part. The third part is the what do you call this?
Chain is not complete.
No. You see this this dead body, as well as the accused person who were caught. For the accused person, there was no medical done to ascertain whether there was any struggle, whether he had the accused person had some scratches or something. There was some fight, some sort of that is not there. Number 4, the IO says in this deposition that he has not visited the site. So therefore, if there was a evidence of struggle in the site, is lost. Therefore, you see, with this 4 gap in the chain, to convict a person on the basis of circumstantial evidence alone, we are finding it difficult. So if you can address us on these 4 points,
No, lordship,
you could have
I
been able to make out a case.
Chain is not complete. But your lordship, on the other hand, on the lapses of the prosecution agency, my lord, lordship, the accused should not get the benefit. There are lordship judgments to that effect. Because in 99, your lordship is aware of, your lordship, 99% cases, lordship, there are lapses in the investigation process.
No, that's why you see, although it's not my, not one of my, it is something which we should not deliberate, but we have done so. That's why we are requesting you as a law officer of the state, as an additional public prosecutor number 1, as senior counsel. I think you should have a deliberation with the prosecuting agencies to bring out those lapses on the part of the prosecution. Huh?
Lordship, our PP has done their, this one, my lord, the seminars and all are held with the officers of the prosecuted agencies, my lord, number of times.
I don't know whether it is reading any result or not, because when I read the CDs produced, in fact, to many people we've been expressing our thoughts. I think Mr. Agadi Chaudhary is there for CBI and NIA. They should be asked to they should be asked to give some sort of training to this to the state police. Whatever has happened has happened, but I think they are good agencies who can whose assistance can be taken in many aspects because of the 2 things. One is documentary analysis of the documents of which can be related to crime. There we have an expertise. Number 1, forensic, they have an expertise that can be looked in, but here if these 4 things are lacking, we don't find that prosecution has been able to show that there was, that the circumstantial leads to no other conclusion but the guilt of the accused persons. That's right. Did your part of the argument?
No, sure, I have completed,
Okay.
I have nothing more to submit. Madam.
Yeah, for the informant. Okay. But please, Ms. Bhuya, we don't want, we are not making any adverse comments here. Because we,
Handicap, my lord, beyond the trial court record, we have nothing to ask, my lord.
because you are one of the, what do you call,
We
persons we can,
found, my lord, if we make, like, even the court asks, are you appearing for the prosecution or the defense? If we, like, concede, my lord.
no, it's
So,
okay.
Give a 100%.
No, it's okay,
if we
it's
will
okay.
Find out something.
It's okay. Uh, Yes, Mr. Mahanta.
I am for the informant, but I have nothing to submit, but obviously submitted my learned friend, so only I point out one two things, the scene of, the scene is from beginning from the PW1, where he about before the occurrence, if Lordship will go by the evidence of PW1
Yes, we are
Then-
there.
at page 11,
Yes.
before the incident, accused were seen with the deceased person. And thereafter PW2, one of the accused was seen after incident. That is the Govinda was the accused who ran away from the courtyard of, from the place of occurrence through the courtyard of PW2. That is.
But you see in the cross-examination, she says, I have not seen who ran away.
Maybe not.
That is one part. The second part is, see, you see, let us say that the timeline is correct. Either it is 7 o'clock or it is 8 o'clock in the evening, correct? But a village person coming and saying that 8 o'clock I was sleeping, is it believable that 8 o'clock somebody would be sleeping?
In the village, blood may happen blood. But they all are cultivated blood. And informant is was as PW10 million. It disclosed why test discrepancy happened in the time.
This PW1, she is a housewife.
PW1 is a teacher.
Hmm?
PW1.
Oh, I'm sorry, PW2, no, PW1.
These are the independent witness, not connected with the accused or such.
No, I'm sorry, I was reading PW2.
PW2 is the house.
Huh. He's a teacher.
And even PW7, though he was hostile, initially he also saw the accused with Martin.
He's the PW10 is the brother,
Lordship, his uncle.
his uncle. But he also doesn't say that the seized bicycle was of his nephew.
Lordship, he's the informant and according to him at 4 PM, though he, because SRR was written by other person, since it's, illiterate, baby call illiterate person, but here, SRR was written by perhaps Niranjan. Niranjan Das. PwC.
Paperbook, where is the postmortem report?
It's 73 though. 73.
Ms. Bhuna,
My lord.
is there anything on record with regard to that GD entry for sending the GD entry sent? Oh, okay, yes. Right, okay. That GD entry for sending the dead body to the for postmortem. Can you look at that, please see? We are not in a hurry, because just take your time and see that.
Request for the Boku PS case number 1 registered.
Mhm.
It was registered on the basis of the file.
I'll tell you the sequence, why we are asking this question. Can you come to the paper book? We'll show you why we are asking this question. Page 1 FIR. FIR last column is 3C,
Number 9, madam.
3C.
Yes, GD number 9.
This is GD number 9. Okay, right. Now, I missed this up. Now you see this, before that, information received date is 1/3/2007. The same page,
Yes, 1/3/2007.
2 PM,
My lord.
correct? GD entry number 9 at police station.
Yes.
Now come to page 65. Sixty-five is the inquest report. Correct. Reference is Boko PS case number 35 of 2007. That means Boko PS case has already been registered by that time. Correct. Here, there is a time I am missing it. Now, please come to the postmortem report. Especially, it starts from 73, come to page 74. Dispatch, that means dead body dispatch time is shown as 1/3/2007 at 10 a.m. Therefore, before lodging of the FIR, body has been dispatched for postmortem examination. Correct. Second is arrival at a dead house is 1/3/2007 at 2:10 p.m. Therefore, FIR is lodged at 2 p.m. 2:10, the dead body is in the postmortem table. That means inquiry was done after body has been sent to what you call the FIR has been registered, numbered, and body sent for examination. That what was the inquest done? Dead body should not have been there. Dead body should not have been there. What inquest was done?
Lordship, but in the, this
No,
one.
I don't know. I'm just showing you these papers. I'm not making an interpretation. I'm just asking questions.
Case diary is of 28/2/2007, 9:30 AM. Etia moi CD Mukoli Korilu, it is of 28/2/2007. So this reference is a 1 3 minor. Next day. Case diary is of, it was opened on 28/2/2007 and 9:30 AM.
But how was it opened? Some GD entry has to be there. What is the first GD entry in the case diary? But then the FIR is wrong. The FIR will have to disclose that, okay, information received, but it is what you call formal FIR is coming at a different time. Something is wrong somewhere. Because the dead body was not there, dispatched at 10 a.m. Inquest could not have been done at all. Except for situation in Mahabharat, where Sanjay can look at the what you call war from huh? Direct telecast. You take your time. We're not in a hurry, but this is it's again something very unexplained.
Sir,
Mr. Mishra, we had been deliberating in the meanwhile. We will be rising at 3 o'clock. May not be able to be taken up. Can you suggest a date where we can fix your matter? Tuesday. Okay. That item was item number?
I'm appearing in 14 and 17.
14, 17. Mr. Chaudhary, convenient to you? Okay, due to positive time, matter could not be taken up today. Mr. D.K. Mishra, Senior Counsel, assisted by Mr. B. Prasad, Counsel for the appellant in item number 14 and 17. So and so, as well as Mr. R.K.D. Chaudhary, Leonard, Standing Counsel for NIA, is present. In other matters, who are there? No, to refer them. You say both sides are present in other items. Both sides are present. List on so and so. So we are saying both sides are present. We are not recording the names. And these two items we record. In the other items. Both are present. It's RKT Chaudhary, it's 8%. Tuesday would be 23 for 2024. So we are saying both sides are present. We have counted. It's okay, you take your time. In the meanwhile, we hear Mr. Madhavi complete his. Ms. B, you can take your time. We'll hear in the meantime, we'll hear him. We'll hear Mr. Madhavi.
Yes.
You take your time. We're not in a hurry.
I'm for respond, respondent 2 minutes here, PW 10 minutes. May I read the statement of
PW 10.
at page 20. That I know the accused person. I also knew the deceit from it. Deceit was the-
Just a moment.
that I know the accused person. I also knew the deceit. The deceit was the son of my elder brother. He died in the year 2007. I was at my residence at the time of occurrence. At about 4 p.m. on the date of occurrence, both the accused person called out or made from my house. He was present in the house at that time. There is college situated away from our house. I heard Hulla near the college about 7 p.m. On the date of occurrence, after hearing Hulla, I rushed to the place of origin of Hulla, that is near the college, and there I heard that Amit was murdered. On being asked, I told the people gathered there that at about 4 p.m. the accused person were with the deceased. The deceased was found the dead by the side of police road at Kahibari. The dead body was in the drain by the side of road. The college I referred to above and the place of occurrence are adjacent. The villagers searched both the accused person home but cannot find them. The affair was logged by me. The affair was written by one Niranjan, that is P2 6 million, as per my version, and was also read over to me after which I had put my signature. Exhibit 5 is the affair. Exhibit 5.1 is my signature. Exhibit 5.2 is the signature of. I am familiar with the signature of Shri Niranjan Das. Exhibit 2 is the inquest report. Exhibit 2 is my signature and cross mirror. In cross mirror, he explained how the discrepancy was happened. I read up to class 6. I have submitted the affair that the accused person called out the receipt at about 8 p.m. on the date of occurrence. although I have stated in my evidence on oath that the accused was called out by accused person at about 4 p.m. The statement given on oath in the court today, the accused person called out the receipt at 4 p.m. is the true time. That is therefore the exact time was the, so when accused going out from the house of the informant is at 4 p.m.
Is the name of the college available? No.
What's it?
Is the name of the college available? No.
No. I do not remember stating to the police that at 8 p.m. on the date of occurrence, the receipt came to my house and then he was called out by the both the accused person. I did not state for police that after hearing Hulla at 7 p.m. I went near the college. That is a place of origin of the Hulla. And on being asked, told the people gathered was that about 4 p.m. on that day itself, the receipt was called out by the accused person. Milord in here, evidence in more particularly cross minority repeatedly inconsistent with the time, that is the 4 p.m. This fact I did not narrate in the affair. I am not the witness to the murder of the house of mine and that the house of the accused is intervened by distance of 5 meters of land. It is not a fact that the place of occurrence is the distance of 4 kilometers from my house. My wife is also known that the accused person followed the deceased person of my house. I did not state this fact to the police. It is not a fact that the accused person did not follow the deceased from my house as I stated. It is not a fact that the FIR is brought in this case against the accused person only on suspicion. It is not a fact that I send the place of origin of Bahula near the college. This is a similar distance away from my house, and that there only I heard that the receipt was killed are all false. Lordship, and now will Lordship kindly have a look at the evidence of PW.
No, before that, we'll come to page 87. I may not remember the topography because I'm not widely traveled, but this Boko has 2 or 3 colleges very nearby. Boko College of Education, that one I think Jawaharlal Nehru College. There is also a Kanya Mahavidyalaya. They are very closely located. Correct. So, this sketch map, A is the college road. E is the Kahibari road. Correct. The PW1 says he is a resident of Kahibari. Correct. And the place of occurrence is shown here at marked as what you call this C, dead body. Now, we don't know the distance of the place of PW1 and this place of occurrence. He hears a call, hears Halla and then runs.
Lordship, that's Milord, all people were gathered there after hearing the event crime. Milord.
No, because he says we are now in PW1. He says that he heard a Halla
Yes,
and then came.
at the time 8, because it was in between 7 and 8 Milord. In rural area Milord, possible Milord.
We can't say because of this proximity of the 3 colleges there.
And if maybe there is maybe instance of
Because if the location is correct, that is not an absolute rural area in Boko. We don't know about this time 2000. This is an incident of 2007. We don't know about 2007, but right now This place, it may not be an absolute rural area where this hue and cry could be heard from Kahibari. Kahibari, I'm not sure.
Because from
What
the
is the
FIR, it
distance?
is a police patrolling post, Milord. So FIR was lost at police post. Probably in a remote area, maybe the place of occurrence is.
No, maybe we can't say for sure.
Anyway, but then Milord, PW1 is specifically stated before the court that both the accused person and before the death of, before the death, Milord, both the accused person and deceased was seen by PW1, Milord. And after PW and PW2, after the occurrence.
No,
yeah,
here I'll tell you why this is to be explained. Is PW10. He is the informant. Now, PW10 in cross-examination says seventh or eighth line. I do not remember stating to the police that at 8 p.m. on the date of offense, the deceased came to my house and then he was called out by both the accused persons. Page 23. Then he says, I did not state before the police that after hearing a halla at 7 p.m., I went to the college place of origin of the halla and on being told, people gathered told me that at 4 p.m. on that day, it said the deceased was called out by the accused persons. This fact I did not narrate in the FIR.
Because I am submitting based on this Milord, material as available.
No, because cross-examination is a must in a. And you see, the house of mine and that of the accused is intervened by a distance of 5 bighas of land.
I become maybe within 400 to 5 millimeter. From here, we can say that this is the remote area because this is the cultivation area.
No, so we can't assume anything. In a criminal trial, we can't assume. We'll go by whatever is there.
So Milord, based on the evidence of PW 10, 1 and 2 Milord. Lots of the trial court come to a conclusion that this.
Okay, what is the point you're trying to make from here?
Lordship, person, as per statement of PW 10, he was taken out from the house of PW 10 Milord unit at 4 p.m. Milord, which is corroborated by statement of PW 1. That is, before that, at the evening time, she was were seen together by PW 1.
Scene theory is at 4 p.m. Yes.
And after the incident, Milord, PW2 is seen the one of the accused, Govindo, to run through her courtyard. That is the. Then I saw the person was running through my courtyard and I could identify as Govinda, the one of the. My humble
Just a moment.
answer, Miller,
Just a moment. Beaucoup.
Lordship, apart from this few things, but BW's 7, though he became hostile Miller, initially he perhaps deposed before, it was under section 161 before the police Miller, that he also saw that he was run through with clay Miller on the body. Lordship will find his evidence at page 17 and 18 is the relevant. In the cross, there is a clear suggestion that regarding that Miller at page 18 Miller. That Mary Miller is not the fact that I stated before police that after coming out from my house at 8:30 p.m., I saw Govinda Mandal and Queen Anand, the accused convicted Miller, ran through the division with clay on their body and found through our road. And after some time, I came to know the said 2% is Miller. Because all these materials, statement, my humble submission completed scene of accountancy against evidence lasting. Probably his 161 statement maybe in the court. His statement recorded by police available in the
We can't keep it. This deposition will prevail over 161. Here it says, I did not say bully before the police. So that goes away. Because the last paragraph of this cross-examination, last 2 lines. I have no knowledge about the involvement of accused with the occurrence, nor I have seen them.
because he became hostile.
No, that's okay.
But
You
initially
see,
the-
you see the difficult parts. The difficult part is that cross-examination again is an art.
Lordship, anyone, because Lordship have to decide on the available material on the record. My submission only on the basis of what I find in the paper with me. So,
So what's the matter then?
I did not wanted to burden your lordship with the judgment, but you has fallen for your lordship now regarding motive. Just I'm handing over one judgment of honorable affairs for regarding motive part. Already reference.
Which
That
one?
motive is
Motive.
important in circumstances.
Oh.
Only that.
That's okay. That would be required.
Paragraph 10, 12, and 15. So 10 is again Sharad Brigadier, I'm not reading. 12 lordship analysis. 10, 12, and 15.
Paragraph
Paragraph 10, 12, and
16,
15.
15. Um, Yeah. Close this matter then.
The formal FIR, its reference is given. Received a Zahar at Somoria TP by GD entry number 3 dated 1307 and forwarded to the OC Boko PS for favor of registering the case. Lordship, but prior to this, Caesar was made by on 28/2.
No, no. We are just informing you that the Boko PS case was registered prior to inquest, because inquest report has that entry.
reference, yes.
So if there is a reference, that means at 10 o'clock, the body was already dispatched. So,
But the contents of GD, I didn't find it.
no, that's okay. The GD entry, we now have a number, but the circumstances you see at 10 o'clock, the inquest was done. Must have been done after this, this has been registered. At 10 o'clock, postmortem says that body was already dispatched. Therefore, when did this, what you call, the inquest at all happened? It takes away the credibility of the prosecution case. We are just trying to connect these two, and we find that when the submission was made about that, we were in fact reading this sequence. That's the only reason we are informing you. For Mr. A. Ahmed, counsel for the appellant, also heard Ms. B. Bhuya, senior counsel, and additional VP for the state, assisted by Mr. J. Das, learned counsel, as well as Mr. M. Mohanto, learned counsel for the respondent number 2. Argument is concluded, judgment is served. Ms. Bhuya, please don't take it as an adverse comment, because we expected not only fairness, but
But my contention is that since it was given, he was not in the custody of police.
no, it's okay. It's okay.
So I'm
We take it.
trying to make a differentiate.
No,
myself so that-
correct.
Item 2, WBC 3308. WBC 3308.
This petition is dismissed.
Item 3, WBC 6104 of 2022. For pronouncement of judgment.
This petition is dismissed and the interim order stands vacated. This judgment will not come in the way for the petitioner number 2 to adopt a fresh disciplinary proceeding against the petitioner. If permissible, by following the due process of law. Correction আছে এটু। Correction আছে।
Item four, WBC 8310/2022.
This writ petition is also dismissed. Oh, imprimatur will have to. Okay, so here there'll be some correction again. I think you give us this book,
Yellow book.
yellow, you will. That yellow book. They can do. Uh-huh. You-
Deep blueprint.
Just- Take it after some time, we'll give it to you. That book.
Item one, bail hearing BA 7/24.
This is a,
How many days now?
now today, your lordship, it is 754
7:34.
as of 754 days. The, there were 3 persons, your lordship. The other.
What is the stage of the trial?
One witness is examined on 11/12/2023. In this case,
I
charge
think-
was framed on 27/10/2023. Although there are 15, some, no, 10 witness. There are 10 witness, out of that, one is examined on 11th of December. And final complaint was filed on 30/11/2022.
Mr. Manan, what is the quantity of drugs seized?
Quantity of drugs used was 807 grams of heroin.
8 gram, 807. According to you, what is the market value, Mr. Kyal?
Lordship,
807 gram,
it's a commercial quantity, lordship heroin,
but the value would be how much?
lordship, just 6,65,000, 6 crore 65 lakhs, 2,060, 600. Mentioned in page 44.
Mr. Manan, after this Satyendra Kumar until
Yes.
it's very difficult to release in these drug offenses.
Your lordship, what has happened, your lordship, subsequently, the until has also stated, that the until has also been stated that in case 37, that there is a violation of 121. So here, then there Ravi Prakash gives subsequent.
Ravi Prakash.
That is already referred in the other two, there are three persons, your lordship, the other 2 persons have been granted bail by this.
Okay.
So the other, this is the driver of the vehicle. The other 2 persons, your lordship, that's why I'm just trying to point out the other 2 matters. I have annexed.
Okay.
So lordship will kindly take up page 152. The facts are also narrated here, so I'm not reading everything. Page 152. This order was 2012-2023. Yes, here your lordship, it has been stated. We just not go into the facts of the matter. So here, your lordship, I'll just take up your lordship page 154, para 6 onwards. Facts are same, your lordship, basically. So I'll just read this from para 6 from page 154. The court has mentioned here.
Yes.
The learned counsel for petitioner has submitted that the petitioner has been languishing behind the bars for last 1 year to 11 months. That was at that point of time. Now it is more than 2 years. For no fault of his. It is also submitted by the learned counsel for petitioner that though there are 15 prosecution witnesses listed in the charge sheet, however, not even a single witness has been examined and the charges were made recently on 27/10/2023. And it is unlikely that the trial will be completed soon. So the charge was framed on 27/10/2023. And only now, as per my learned friend, the one witness has been examined on the last occasion. Now, it is further submitted by the learned counsel for petitioner that the petitioner is entitled to get bail mainly on the ground of prolonged incarceration as per the observations of the Honorable Court in Mohammed Muslim versus State and City Delhi, reported in 2023 SCC Online SC 352, as well as Ravi Prakash versus State of Orissa. This is more recent, your lordship. The citation is not there. It has been mentioned, order dated 13/7/2023, passed in special leave appeal number so and so. The apex court has observed in the aforementioned cases that prolonged incarceration overrides the embargo of section 37 of the NDPS Act. Learned counsel for the petitioner has also cited the ruling of apex court in Manmandal versus State of Bengal, order dated so and so. This is also more recent, 14/9/2023, as well as Tapas Mandal versus State of Bengal. That is also on the same, when the petitioners were granted bail in spite of the restrictions under section 37 of the NDPS Act, only taking into consideration the fact that they were incarcerated for a period of almost 2 years, and the trial is not likely to be taken up for hearing immediately. Learned counsel for the petitioner has also cited the ruling of the apex court in Sariful Islam versus West Bengal, Nitish Adhikari versus State of West Bengal, and Mohammad Hanif Sheikh versus State of Gujarat, in which the apex court granted bail to the petitioner facing charge for possession of commercial quantity of contraband on the ground of prolonged incarceration. On the other hand, the learned standing counsel NCB has vehemently opposed the grant of bail to the present petitioner on the ground that the quantity of contraband in the case is a commercial quantity and therefore the embargo of 37 is applicable here in this case. Learned standing counsel NCB has also submitted that unless the parameters of bail available under section 37 of the NDPS Act are satisfied, the bail cannot be granted in case of involvement of commercial quantity of contraband. In support of his submissions, he has cited the ruling of Narcotics Control Bureau versus Mohit Agarwala, reported in 22/6 Supreme 580. Learned standing counsel NCB has also argued that unless the twin conditions mentioned in section 37 of NDPS Act are satisfied, bail may not be granted to the petitioner. To substantiate his submissions, he has also cited the ruling of apex court in the case of Union of India versus Ram Samuz and another reported in 1999 Swens. He has also submitted that there cannot be any fixed tenure for completion of a trial in NDPS cases, and this case has to be decided on the facts and circumstances specific and particular to the said case. He has further submitted that the question as to whether the petitioner has been deprived of his right of having speedy trial due to the unreasonable delay shall have to be considered, taking into consideration various factors like the length of the delay, justification for delay, the accused's assertion of his right to speedy trial, and prejudice caused to the accused for such delay. It is submitted by the standing counsel NCB that in the instant case, the prosecution side was not at fault for causing delay in trial, as for a brief period, the court in which it was earlier pending, that is Court of Learned Additional Session Judge number 5, was vacant for about 3 months, and thereafter the case was transferred to Court of the Learned Additional Session Judge number 2. Hence, the delay was caused due to non-availability of presiding officer, and the prosecution was not at fault, and for that, no benefit for the same should be granted to the present petitioner while considering his bail application. Learned counsel for NCB also submitted that though the right of to speedy trial of the petitioner is of great importance, the balance has to be struck between the right of individual liberty and this interest of society. And in this case, commercial quantity of heroin has been seized from the possession of the petitioner merely on the ground of long incarceration. The petitioner may not be entitled to get bail, and other facts and circumstances such as interest of society shall also be considered in the case. In support of his submissions, the learned counsel to the petitioner has cited the reading of Apex Court in Chandrasekhar Prasad Shandu Babu versus State of Bihar, reported in so and so, when it was observed. We have cautiously analyzed the rival contentions and the materials available on record. For obvious reasons, more particularly having regard to the present stage of case in which the impugned order has been passed, we consider it inexpedient to dwell on factual detail. The crux of this charge against the respondent accused in the case is that he has entered into a conspiracy with furtherance thereof, has eliminated a witness in an earlier case against him under section 302 so and so IPC before he was to finally testify in support of charge. This court in Rajesh Ranjan Yadav, that is Papu Yadav versus CBI, 2007, balanced the fundamental right to individual liberty with the interest of the society in the following terms in paragraph 16. Therefore, we are of opinion that while it is true that Article 21 is of great importance because it enshrines the fundamental right to the individual liberty, but at the same time, a balance has to be struck between the right to individual liberty and the interest of society. No right can be absolute and reasonable restrictions can be placed on them. While it is true that one of the consideration in deciding whether to grant bail to an accused or not is whether he has been in jail for a long time, the court has also to take into consideration other facts and circumstances such as the interest of the society. 60. Learned Standing Counsel also pointed out towards the statement the objects of the reason of amending Act 21, which brought amendment to the NDPS Act 90, wherein the intention of legislation was rationalized in sentence structure so as to ensure that while drug traffickers or who traffic in significant quantities of drug are punished in deterrent sentence, the addict who commit less serious offences are sentenced to less severe punishment. In the instant case, as the quantity of contraband seized is of commercial quantity, it is submitted the court should not take any lenient view in the matter while considering the application for bail in this case. I have considered the submissions made by the learned counsel for both the sides and has perused a scanned copy of the case record of NDPS case number so and so along with other relevant documents available on record. On perusal of the case record, it appears that in the instant case, the petitioner was arrested on 5/4/2022 and was produced before the court on 6/4/2022 in connection with seizure of 807.18 grams of suspected heroin from his possession. However, the search sheet was laid on 1/12/2022 against the present petitioner and other accused persons. One of the co-accused, namely Abdul Rahman, was shown as absconder in the charge sheet, and thereafter on several subsequent dates, the petitioner along with the other co-accused person were produced before the learned trial court on 6/3/23 as well as on 24/4/2023. The prosecution side took adjournment, whereas on 23/2023, he engaged counsel for the present petitioner sought adjournment. It also appears from the record that from 3/6/2023 to 8/9/2023, that is for about 3 months, due to the transfer of the presiding officer, the case of the present petitioner remained pending, and it was transferred to the Court of Additional Session Judge number 2 on the basis of transfer petition filed by one of the accused persons. This is important. Thereafter, on 27/7/2023, the charges were framed and no witnesses has been examined till now. Now, after that, you will see one was examined as per my learned friend. Next week, it appears that though the prosecution side took a couple of adjournment, the prosecution side may not be blamed entirely for the delay caused due to the transfer of the learned presiding officer of the trial court. The said court was vacant for at least 3 months. However, it is true that the present petitioner was also not at fault, as he has been detained behind the bars throughout the trial. Under Article 21 of the Constitution, of the petitioner also has the fundamental right to get speedy trial, and he may not be denied of the said right for whatsoever reason, if he himself is not at fault for the same. If the trial court could not proceed expeditiously, he is at least entitled to get bail during the pendency of such trial, and it would be unjust to keep him under detention during pendency of such trial. Honorable Supreme Court in Muhammad Muslim so and so has observed, grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37 of the NDPS Act. And also considering the observation of the Honorable Supreme Court of India in Ravi Prakash versus State of Odisha reported in Swenso, wherein Honorable Supreme Court has observed that prolonged incarceration generally militates against the most precious fundamental rights granted under Article 21 of the Constitution of India. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. This court is of the considered opinion that if this court comes to finding that there is an undue delay in completion of trial and there is prolonged incarceration of the petitioner, he would be entitled to get bail as in such case of prolonged incarceration. The fundamental right of life and liberty under Article 21 of the Constitution of India would outweigh the fetters imposed under Section 37 of the NDPS Act. It is also pertinent to mention herein that the Honorable Supreme Court of India has granted bail to the accused facing charges of possession of commercial quantity of contraband only on the ground of prolonged incarceration in so and so, Sariful Islam versus State of West Bengal, wherein the accused was detained behind bar for 1 year and 6 months. In Nitesh Adhikari versus State of West Bengal, order dated so and so, Honorable Apex Court granted bail to the accused facing acquisition under Section 21C of the NDPS Act on the ground of incarceration for 1 year, 7 months. Similarly, in Mohammed so and so, the petitioner was granted bail by the accused Apex Court on the ground of prolonged incarceration for 2 years. In Tapas Mandal and Man Mandal, the Apex Court granted bail to the petitioners before it is taking into consideration the fact that the petitioners have been incarcerated for a period of almost 2 years and the trial is not likely to be taken up for hearing in the immediate near future. And has already observed hearing before that though the petitioner has been languishing behind bar since so and so, the trial has progressed only up to the stage of framing charges and not even a single witness has yet been examined. Even the interest of society would be in expeditious hearing of such cases. Under the facts and circumstances of this case, considering the slow progress of the trial and prolonged incarceration of the petitioner, this court is the opinion that the fundamental right granted to the petitioner under Article 21 of the Constitution of India would outweigh the fetters imposed under Section 37 of the NDPS Act 1955 in this case. In view of the above petitioner is allowed to go on bail on the amount of so and so with the following the lordship conditions. So this was the finding first case. The second case also annexed your lordship, that page 163. It is basically the same. The other person concerned, this is Leki Ami, and mostly it is also it reflects similar order with regard to the earlier case. And both these persons were granted. Only the driver of the vehicle, who is presently before your petitioner, has come on the same ground of prolonged incarceration. Now the prolonged incarceration is more than 2 years. And your lordship, the second part, here your lordship, the other persons have already been granted bail by this court. And your lordship, so in parity, your lordship, he is also entitled to basically. And the only thing is that though 11 witnesses are there, only one has taken place. And it is between the last order and till today. So even there are another 10 witnesses left. And there is no question that this trial will be over in a near future. This in Ravi Prakash, it was very clear, your lordship, the court has stated that under 37 fetters will not be done. 21 is violated when there is a prolonged incarceration. So that is basically.
Yes.
If I've submitted one report of IO, I could not file because it was not in proper form of exhibit. What's it besides this? What's it seen the order passed by the coordinate bench of this honorable court? What's it I am without wasting the time of I'm relying on one judgment. Honorable Supreme Court announced on 20th of November 2023. This is Tarun Kumar versus Assistant Director Enforcement. What's the paragraph 15 to 21 may kindly read. Some lines in bottom, probably there are not be properly.
Paragraphs?
Paragraph 18 to 21. Married.
NDPS Act देव ना NDPS Act. Wait. P25. याते नंबर থাকে P हाँ, P
ये नंबर follow करो।
Okay, I'm listing it on Tuesday for delivery of orders.
Take one more judgment, recent judgment by this coordinate that I'm just handing over here. Where the same matter, same incarceration. Coordinate. And they considering the same prolonged incarceration. the court has said. Here, one more thing, also parity was also there. And that case also the parity has been considered. The parity is- Since the facts are and material, everything is similar. So therefore, I'm not making further answer. It is only on the technical.
This
For
parity,
also
in
fancy.
fact, parity,
Parity, you're not saying.
I have authored an order
Yeah.
where I've Distinguished, I've said that parity is not available in bail matters.
Yes, Lordship, this is a law, as on date. Lordship, further,
It was long
And your
back.
lordship, there has to be some distinguishing factor between two.
No, the concept of parity, all notwithstanding with that, even in these judgments, courts have referred to the principle of parity, but Supreme Court has said it is not.
Supreme Court has said it is not. That your lordship will have to see whether the parity with regard to the facts and circumstances of both the cases are different. But I think Urban's right. Urban Singh versus State of UP. Your lordship has relied on the judgment where it has said that bail simply cannot be granted on parity. That is the ground. Because that Supreme Court in that case say it cannot be granted on parity, but the role and offense of the are also relevant in that.
Yes, yes,
That is the judgment.
yes.
Here, your lordship, the case will be with regard to prolonged incarceration. I am on prolonged incarceration, it is violation of fundamental right. And your lordship, the honorable court in Ravi Prakash and the other cases that has been cited has clearly indicated that 21 is violated, 37 will not. So this is apart from parity, lordship, for the timing, if parity is also not taken into consideration, then that factor comes. Whether the Article 21 is not violated, whether the accused is guilty of delaying the matter, that will come into. If your lordship finds the accused is guilty of delaying the matter, then obviously he will not be granted. But if he is not delayed the matter, it is no fault of his, which report has found in the other two cases. In that case, your lordship, prolonged incarceration. And in that case, your lordship, 37 will not be granted. So that is basically the whole matter. That is why your lordship, both the other persons were granted bail, not on parity, on the ground of prolonged incarceration. And similar matters, your lordship, many other matters are there. I've just given the recent one, which I've got yesterday by this honorable court. So here also, basically, prolonged incarceration, violation of Article 21. Parity is a line there, but court did not ultimately take into consideration that. Because these matters were not on merit.
Okay.
Lordship, I have just two submissions. Lordship, there are many judgments of coordinate bench where bail has been rejected when the particular petitioner were jailed in for more than 4 years or 4.5 years. I'll produce the judgment. Secondly, Lordship,
But you have to give it today because I'm fixing the matter on Tuesday because I'll be traveling. I'll come back on Monday morning, so you have to give it in course of the day.
Lordship, another thing. And in Muhammad Muslim, this is a leading judgment. Where, Lordship, the facts of the case was that the petitioner was in jail for more than 7.5 years. There were 62 witnesses. And out of 62, 30 were examined only. till for about 7.5 years. And in case of Ravi, Lordship may please to consider that in Ravi and other four orders referred by, these are only orders of 1 page or 2 pages. No facts have been considered, so that cannot be a binding
Still,
precedent.
I'll be bound by that,
No, Lordship, when then,
No, in para 3 of Praveen
No,
Prakash,
no,
the
Lordship.
facts are.
because it says 2 years.
no, Lordship.
We can't examine
No,
the,
No, no, Lordship, but there is a recent judgment where Supreme Court explained which judgment should be taken as a binding precedent. If you could, I'll place that judgment also. Yesterday I placed before Honorable Court number 24. also. Today,
give it to the court
it is
master.
Not with me today.
We give the citation, the copy is not required. Just give the citation, we'll take it up.
Lordship, in this case, Lordship, may please to note down the dates. The petitioner was arrested on 5/4/2022. Then final complaint was filed on 30th of 11/2022. Charge was framed on 28
Just a moment,
27.
27.
just a moment.
It is recorded.
So we consider, when we consider that the prolonged incarnation Lordship, only in this case, that principle not being applicable in this case.
I don't know, just tell me the dates.
Lordship, the petitioner was arrested on 5/4/2022. They were produced on 6.
5/4/22.
Then final complaint was filed on 30th of November 2022.
11,
30/11/22.
30, 11, 22.
Then charge was framed on 27/10/23.
27,
27/10.
10, 23.
And PW one was examined on 11/12/2023. Yes, we submitted, but the court didn't record that. Anyway,
11/1/24.
yes, 23. Now it case.
No, you said 27 charges were framed on 27, 10, 23.
23. And PW one was examined on 11/12/23.
11, 12, okay.
Out of 10 witnesses, one has been examined till date. And next date is probably fixed in the first week of February. For PW two and all.
Okay.
I'll just make one submission. My learned friend has been submitting this fair, but if he finds that this judgment, earlier judgment is not correct and wrong, then Lordship cannot see over that.
Lordship, just for information, your Lordship department is pursuing the matter file SFP.
That's okay, that's okay. That's separate,
I'm
but
not arguing on that.
we all know what weightage it will carry.
Yes,
We have to be conscious of that.
and Lordship, this is Chanuk Kumar case, Lordship, paragraph 18 to 20 is a very clear with regard to granting of bail. In paragraph 20.
But that is with regard to PMLA.
Lordship, the same provision is there.
That is.
No,
also
no.
Section
No,
45.
no, in PMLA, there's a distinction. The marked distinction between the two is that in PMLA, there's a authority of Supreme Court on the point that PMLA matters as it is what you call financial, what you call offense, therefore economic offense,
Lordship,
and
then-
therefore,
Then this is the more serious offense of narcotics.
I don't know.
I can place one judgment, Lordship, on Supreme
Then
Court
your
says that
Lordship, if
that
the-
is to be seen differently from other offenses.
No, you should, because you see, bail matters, I can't keep it prolonged, I can't keep it reserved for judgment for long.
No, Lordship,
Because-
if I'll put it, this one on Monday, Lordship, allow me some.
No, Monday, because then I'll have no time to,
Lordship may fix at 4 o'clock. I'll sit, only I'll place more judgment, Lordship. With regard to.
they give it to the court master. It will not be fixed again.
Then I'll give.
It will not be fixed again because I am not taking
No,
up
no.
regular rosters. I am been assigned
Lordship, on
division
Monday,
bench.
I'll have a copy of the judgment.
Okay.
Much of that.
The submissions of Mr. Vyas Manan, counsel for the petitioner, as well as Mr. S.C. Kalan as standing counsel for the respondent is concluded. So the learned standing counsel for the respondent pays for permitting him to provide copies of few case citations on in the morning of 1/20/24 to the court. So the same may be given to the court master.
Lots.
List on 22 for delivery of orders.
23rd.
23, 23,
Much,
one for delivery of orders.
much of it.
Item 5.
Yes.
I think my lord, she is going to the driving. She was going to the. Here, my lord, only. Page 4, my
Oh,
lord.
that pharmacy case.
She is going back. Tuesday.
When did the death occur?
Death occurred, my lord.
Nine three 2023.
9?
That is postmortem report.
8/3 now.
Death was occurred on 8/3
8.
and PM was done on 9/3.
8/3/23. It's almost a year now.
Only, my lord,
Give him bill you, what you call, let him cooperate, because otherwise what you call uh, what you call this, charge sheet will it'll delay the trial.
Otherwise, there's a bail
my
opposition.
lord,
prayer.
Huh?
You kindly go through this.
my lord, only, my lord, my submission is a simple submission, my lord. Whatever the client says, my lord, we believe it, my lord. To be honest, my lord, to be fair enough, my lord, I do not believe the client. That's why I have made the informant as a party here. According to the petitioner, my lord, page 4, my lord, he said, my lord, page 4, my lord. He came, page 4, my lord, paragraph 6, for a once, my lord. Paragraph 6A, my lord, he came to know that the informant had approached the concerned investigating officer and stated that he was not sure about the pharmacy in which the deceased was given injection. My lord. So this is what the client says, my lord. So therefore, I made the informant as a party.
No, first of all, you see, he does not have a pharmacy.
Without having license.
He does not have a pharmacy. If you project that it was a pharmacy, it would not be correct.
That's,
You see, last time I told you, you've seen the license.
yes, yes.
It is in Form 21B. 21 Form 21B is for wholesale.
So, my lord, whether I was in the.
Because it's not a pharmacy. That's why I told you on the last occasion.
Yes,
Because if you have a license, pharmacy license, operative for 21B, then you could not have operated 21A.
and moreover, my lord, his son is pursuing the pharmacy course, my lord, and he is not a pharmacist.
No, that is a part, but he's a license not for a retail pharmacy. It's a wholesale.
Now the question is, my lord, whether that is being injected in my shop or not. My lord. The clinics may not be correct, but the English may not. That's why, my lord, I have made the informant as a party, my lord. Look for no other reasons, my lord.
I have a special, what you call, inclination to learn about medical and
Yes.
so
I know.
I am
Yes, I leave it
more
to her.
comfortable. No, just a moment. She has given us her objection. Let us see. This